Mr. Lyons, are you ready to proceed with Mr. Fenton?
Good morning, Your Honor. I am. Question, Your Honor, did the court receive my paperwork with regard to Mr. Fenton, the plea agreement as well as the advisement of right?
I do have that, yes.
Thank you, Your Honor. Now we are prepared to proceed to a no contest plea pursuant to that agreement.
Okay, this is file 18-19189-FC, People versus Michael Davis Fenton. We are here today for a pretrial conference, and we are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. McClure.
B.B. McClure, may I have the people?
May it please the court, George Lyons, on behalf of Mr. Fenton.
All right, and I do have a copy of a plea agreement as well as a signed advice of rights form. Mr. Lyons, do you want to place your understanding of the plea agreement on the record, and then I'll ask Ms. McClure to confirm.
Thank you, Your Honor. My client will be tendering a no contest plea to count 4 of the information that was his first degree relationship. The people will dismiss all other charges that 1, 2, 3, and 4. We have a Cobb evaluation. The court did indicate he was sentenced him between 144 and 156 months, Your Honor. That is the sum total of my understanding.
Okay, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, and I just want to make sure it's clear that on the plea agreement, we've also check marked the box pursuant to statute that conviction of this crime will result in this defendant being required to register under the Michigan Sex Offender Registration Act. It also requires him to be subject to lifetime electronic monitoring.
Your Honor, that box was not only checked. My client and I discussed that thoroughly Monday when he and I met at the jail.
Mr. Fenton, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Do.
And you are Michael Davis Fenton, correct?
Yes.
Mr. Fenton, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contests today to count 4 criminal sexual conduct first degree?
Yes.
And if you understand that the maximum possible penalty for that offense is up to life in prison?
Yes.
Do you understand that it also requires mandatory lifetime electronic monitoring?
Yes.
And do you understand that it also requires that you register under the Michigan Sex Offenders Registration Act?
Yes.
Are you satisfied with Mr. Lyons and the advice that he's given you?
Yes.
Neither the prosecutor nor the defendant or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as it's been stated on the record here this morning. Is that correct, Ms. McClure?
It is correct.
Mr. Lyons?
Yes, Your Honor.
Is that also your understanding, Mr. Fenton?
Yes.
If a plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial. And if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Fenton, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about May 1st, 2018 through September 25th, 2018, in the city of Illinois, county of Illinois, state of Michigan, that you did commit the offense of criminal sexual conduct first degree?
No contest.
Has anybody made any threats or promises to you to induce you to plead no contest to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that that plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes, just other than the Cobb's agreement, that's all that was discussed.
Okay, so do you understand that you're giving up any and all claims that the plea was given as a result of any other threats, inducements, or promises other than that?
Yes, I understand.
Do you understand you're also giving up any claim that it was not your own choice to enter this plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Fenton to plead guilty, to plead no contest today?
No, Your Honor.
No, Your Honor.
Mr. Fenton, other than as we've talked about it on the record today, has your attorney promised you any other particular sentence or estimated what your sentence would be?
I'm sorry, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've talked about it on the record today?
No, sir.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Is it your own choice to plead no contest today?
Yes.
All right, and Ms. McClure, how are we handling the factual basis?
Your Honor, I would just ask that Mr. Lyons stipulate to the facts, and I'll place them on the record. The facts as detailed in Adrian Police Department Report 18-00-11994, authored on September 22nd, 2018 by Detective Lamar Ruffner. And if that's stipulated to, I will place those facts on the record.
Your Honor, respectfully, I have no problem stipulating to those facts.
Okay.
Therefore, the people would ask that this court find that during the time period of May 1st of 2018 and September 25th of 2018 in the city of Adrian, county of Illinois, and state of Michigan, that this defendant, Mr. Fenton, was the legal father of a 6-year-old with the initials GF, and that they were also members of the same household. And that during that time period, he did put his penis inside of her vagina for purposes of sexual gratification. That afterwards she had went to the hospital with notable wounds in her vagina and disclosed this behavior. And based on that, I would ask the court to find Mr. Fenton that we have met the factual basis for that charge.
All right, I do find based on those stipulated facts that the factual basis for count 4, criminal sexual conduct first degree, have been met. Has the court complied with NCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Lyons?
The court has, thank you.
I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Fenton has had full knowledge of his rights, and he has had competent counsel. The court has not made any agreement other than, as we've talked about on the record here today, regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer the matter to the probation department for a pre-sentence investigation and set sentencing for October 31st at 8:15 a.m.
Your Honor, may counsel appear by Zoom, or would the court prefer I be there in person?
Mr. Fenton, you have a right to be present in person for the sentencing hearing. If you wanted to do it by Zoom, I don't mind that, but you would have to waive your right to be present in person. Do you know which you would prefer?
It's in person, we fine.
Okay. If that's the case, then Mr. Lyons, I would like you to be here in person also.
Not a problem, Your Honor. May I just check my calendar very quickly to make sure that that's a Friday morning, correct?
Correct.
Your Honor, is it possible to go to the end of your docket? I only say that because I have several 8 o'clock and 9 o'clock pretrials in Jackson.
And Your Honor, if that's the case, just given that there may be a child who wants to speak at sentencing, I would just ask that maybe we get a different date where she wouldn't have to wait around all morning for this.
Okay. I could do November 6th or November 7th, which would be the next week.
November 6th, that's the Thursday, Your Honor?
Correct.
That's not a problem, Your Honor.
The people are unfortunately unavailable those 2 days.
Good.
I'm sorry.
Judge, what was the other day?
The people are not available on either of those days, so the next week would be November 13th or 14th.
13th works for me.
I'm available then. Thank you.
Okay, so November 13th at 8:15 a.m.
Thank you, Your Honor.
All right, Mr. Fenton, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay.
Okay, I think we're all set then with your case today, Mr. Fenton. You can let the officer with you know that you are done with court for today.
Thank you, Your Honor.
Thank you.
Phoebe, will you check your message?
Yep, I answered you, I think. Oh, maybe.
Thank you.
And I forwarded you the signed plea agreement as well.
All right, Mr. Dagger-Margosian, are you ready to go back on the record with Mr. Colwell?
Yes.
Mr. Colwell? Okay, so we're back on the record in file 25-22125-FH. People versus Christopher Joseph Colwell. Mr. Dagger-Margosian, you've had a chance to speak to Mr. Colwell in a breakout session. You know how he would like to proceed.
We'll proceed to sentencing.
All right. Okay, so it will be the sense of the court then that Mr. Colwell pay a fine of $2,000. There is a court cost of $750, a supervision fee. State cost of $30, a crime victims fee of $75. You do have the ability, Mr. Colwell, to request an appeal of that sentence. I'm going to ask you to stay here in the courtroom until we get you your 3 copies of a notice of right to appellate review and request for appointment of attorney forms. When they give that to you, you're going to need to sign 1 copy of it. And give it back to us. That just means you got your copies of the form.
Okay.
If you wanted to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days.
Okay.
You understand that?
Yes, Your Honor.
So you can just take a seat back where you were. We'll get you that form as soon as it's prepared.
Alrighty.
Mr. Dagger-Margosian, do you need to speak to Mr. Coleman?
Not unless he needs to speak with me right now. We're ready to enter pleas on these cases.
Okay, Mr. Coleman, do you need to speak with Mr. Dagger-Margosian before we get started?
No, Your Honor.
Okay. Okay, this is file 25-22283-FH and 25-22320-FH, People versus Joshua Glenn Coleman. We are here today for a pretrial hearing in both cases. There are also pending contempts in both cases, and we are proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Ms. McClure?
PB McClure, on behalf of the people.
Michael Dagger-Margosian for Mr. Coleman.
And Mr. Dagger-Margosian, how is Mr. Coleman going to proceed today?
Your Honor, Mr. Coleman will be entering a plea of use on both cases. 2 uses total, 1 on each file.
Yeah, I have an appointment.
I had previously prepared amended information on each file. Does the court have those, or do I need to?
Yeah,
forward
sorry, I
those?
was just flipping through the file, trying to find that, and actually, I've got to find the other one on the computer because I only have one of the files. Yeah, files. Okay, Mr. Coleman, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Joshua Glenn Coleman, is that correct?
Yes.
Mr. Coleman, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty in file 25-22283-FH to count 2, use of methamphetamine?
Yes.
Is it also your intention in file 25-22320-FH to plead guilty to count 2 in that one as well, also use of methamphetamine?
Yes.
Do you understand with respect to each of those charges, the maximum possible penalty is up to 1 year in jail and or $2,000 in fines?
Yes.
Are you satisfied with Mr. Dagger-Margosian and the advice that he's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
Judge, just because I didn't get a chance to verify the full plea agreement, I just want to make sure the record's clear. In exchange for his plea to use of meth on both files, the people will dismiss the felony possession of meth and the habitual offender notice on each file. In addition, based on a 2022 conviction for felony possession of controlled substance out of Ohio, the people would object to 7411 status on both files, and that is on the plea agreement. So I wanted to make sure that was on the record.
Thank you, Ms. McClure. Is that all accurate, Mr. Dagger-Margosian?
Yes.
Is that also your understanding, Mr. Colwell? I'm sorry,
Coleman.
Yes. Yes.
Okay. All right. So other than that, then, Ms. McClure, is it accurate that neither prosecutor, defendant, or anyone acting on the defendant's behalf does possible?
That is correct.
Mr. Dagger-Margosian,
Correct.
is that also your understanding, Mr. Coleman?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify if you wanted to testify. You have the right to be present at your trial and have the witnesses against you appear, and you have the right to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. Do you understand, Mr. Coleman, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime could result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge in file 25-22283-FH that on or about February 18, 2025 in the city of Adrian, County of Lenawee, state of Michigan, you did commit the offense of use of methamphetamine?
Guilty.
And how do you wish to plead to the charge in file 25-22320-FH that on or about June 12, 2025 in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of use of methamphetamine?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Coleman to plead guilty today?
None, Your Honor.
No.
Mr. Coleman, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but does not limit it to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes.
Mr. Dagger Margosian, do you want to establish the factual basis?
Mr. Coleman, on February 18th of this year, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes.
And on that day, I'll satisfy the greater for the lesser. On that date, did you have in your possession methamphetamine?
Yes.
Did you know that it was methamphetamine?
Yes.
And you did not have a legal right to possess it at that time?
No.
Okay. And I'm satisfied with that count.
Satisfied.
And similarly, Mr. Coleman, on June 12th of this year, were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes.
And again, were you in possession of methamphetamine on that date?
Yes.
You knew it to be methamphetamine,
Yes.
and you didn't have a legal right to possess it at that time?
No.
Okay, I'm satisfied. Thank you.
Satisfied, Your Honor.
Okay, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Dagger Margosian?
Yes.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Coleman has had full knowledge of his rights and had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I'll refer this matter to the probation department for a pre-sentence investigation. We can set sentencing for October 31st at 8:15 a.m. Mr. Coleman, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
All right.
Right, you can let the officer with you know that you're done with court for today.
Do I just put the contempt of the
Oh,
sentencing?
I'm sorry, Mr. Dagger Margosian, did he want to do something with the contempt today?
If we could just push it to the sentencing, I think that would be appropriate, please.
All right, so I'll set those over to the October 31st date as well. All right, Mr. Coleman, you can let the officer with you know that you're done with court for today.
Thank you.
Okay, Ms. Underwood, I have Mr. Brown here in the courtroom. Do you need a breakout session with him?
Yes, Your Honor. Thank you.
Mr. Brown, if you'll step outside to the hallway, I'll put that in a breakout session with you and Ms. Underwood. Okay, Mr. Brown, if you're there, I'm going to send you a request to start the video on that iPad and then unmute it. And now I'll put you in the breakout session. Okay, Mr. Brandt, are you ready to proceed with Ms. Bersiaga?
Yes, Your Honor.
Okay. This is file 25-22115 FH, People versus Kabrina Leanne Bersiaga. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Alfred Brand on behalf of the defendant.
And Mr. Brandt, do you have a plea agreement? Is it Ms. Bersiaga's intention to enter a plea today?
That is correct, Your Honor.
Okay, do you want to state your understanding of the plea agreement on the record? I'll ask Ms. Arnold to confirm.
Okay,
Thank you, Your
Judge,
Honor.
actually, it might be better if I put it on the record, if the court's okay with that.
Fine with me.
Okay, so the defendant is going to plead to count 1 listed on the felony information dated January 30th, 2025. In exchange, the people are going to dismiss count 2 and the controlled substance second offense notice. There's a Cobb's evaluation from 9/19/2025 where the court indicated the court will abide by the recommendation of the probation department for sentencing for this matter if the probation department recommends no immediate jail be imposed. Additionally, there is a term both parties have agreed to, and it states as follows. Defendant has represented that she has no knowledge of any controlled substances and controlled substances paraphernalia located in her residence found anywhere else except for the items found in the master bedroom as described in the police report for the charged offenses, which is RHN 42-24. As a condition of this plea agreement, defendant shall not testify in any other proceeding or claim responsibility in any way for any controlled substances or controlled substances paraphernalia located outside of the master bedroom, as she claims it is the truth that she has had no knowledge of these items in her residence. And besides that, the other standard terms of our plea form would apply.
Okay, Mr. Brandt, is that a complete and accurate statement of the plea agreement?
It is, Your Honor, and my client was in my office yesterday. We went through that in detail.
Okay. Ms. Bersiaga, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Kabrina Leanne Bersiaga?
Yes.
Ms. Bersiaga, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of cocaine less than 25 grams?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $25,000 fine?
Yes.
Are you satisfied with Mr. Brandt and the advice that he's given?
I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been addressed on the record here today. Is that correct, Ms. Arnold?
Yes, Your Honor.
Mr. Brandt?
That is correct, Your Honor.
Is that also your understanding, Ms. Bersiaga?
Yes.
If a plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Bersiaga, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
I do.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
I do not.
Do you understand that you're giving those rights up?
I do.
How do you wish to plead to the charge that on or about February 6, 2024 through August 6, 2024, in the city of Adrian, County of Lenawee, state of Michigan, that you did commit the offense of possession of cocaine of less than 25 grams?
What was the first date? I'm sorry.
The dates were February 6, 2024 through August 6, 2024.
Yes. I'm not quite sure. I know August 6th is the date. I don't know what February 6th is.
It's just for the record, so Ms. Bersiaga understands it's a date range because you had the charge of maintaining a drug house. So anytime between February 6, 2024 through August 6, 2024. Anytime in that date range.
Yes, I plead guilty. Right? That's what I'm supposed to. Yeah, I plead guilty.
Okay. Has anybody made any threats or promises to you to get you to plead guilty to that charge?
No, they have not.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Bersiaga to plead guilty today?
No, Your Honor.
No, Your Honor.
Ms. Bersiaga, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've talked about it on the record here this morning?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I do.
Is it your own choice to plead guilty today?
Yes, sir.
Mr. Brandt, do you want to establish the factual basis?
I can, Your Honor. Ms. Bersiaga, on August 6th of 2024, you lived in the city of Adrian, Lenawee County, state of Michigan, correct?
Yes.
And on August 6th of 2024, police officers executed a search warrant and in your master bedroom found a small amount of cocaine that was for your personal use. And as I've indicated to you, to use, you have to possess. You understand that?
I do.
And you had every reason to believe that was in fact cocaine, correct?
Correct.
And for the record, you are acknowledging on the record that you did not know about any other paraphernalia or controlled substances within the house outside of the master bedroom, correct?
Correct.
Nothing further, Your Honor.
All right, Ms. Arnold, are the people satisfied?
We are, Your Honor.
I will accept the plea. It's been given understandably, voluntarily, and accurately. Ms. Bersiaga has had full knowledge of her rights and she has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for October 31st at 8:15 a.m.
Judge, I believe both parties are requesting that sentencing for Ms. Bersiaga be set after the co-defendant Fred Shears' trial, if that's possible, which is an alternate, I believe, December 2nd to December 5th. I know Miss
That's correct, yeah.
Bersiaga has been doing well on bond conditions, so I don't think there's any harm in delaying to that time.
Okay. I forgot that had been mentioned and I forgot that, so I apologize. What dates did you say that trial was?
It's an alternate, the 2nd to the 5th.
Okay. So let's set it then for December 11th at 8:15 a.m.
What was that date, Your Honor?
December 11th.
Okay.
So Ms. Bersiaga, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay.
I'm going to put you in a breakout session with Ms. Teskey from the probation department. She's going to collect some information from you and give you some instructions on what happens next.
Okay.
Mr. Brandt, do you want to be in that breakout session also?
No, Your Honor.
Okay, so Ms. Bersiaga, when you're done talking to Ms. Teskey, you can go ahead and just leave the meeting.
Okay.
Allison, I'll need a copy of that plea agreement form as well, please.
I saw your email pop up. I'll send it right now.
Thank you.
All right, thanks.
Okay, Ms. Underwood, are you ready to proceed with Mr. Brown?
I hope so, Your Honor.
Could you call the jail for Crabtree? Okay, Mr. Brown, you can come forward and sit at the table here closer to the television. This is file 22-20742-FH, People versus Bradley Dwayne Brown. We are here today for a pretrial conference in this case. We are proceeding today by video conference, partially by video conference and partially in person. And we're also here in addition to pretrial for a contempt for failure to appear at a pretrial on July 27, 2022. First name of the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Your Honor, Rhonda, I'll do it for Mr. Brown this morning.
And sir, you're Bradley Dwayne Brown? Yes, sir. All right, Ms. Underwood, where do we stand with Mr. Brown's case today?
This is interesting, Your Honor. While Mr. Brown, we didn't see Mr. Brown for a while. Mr. Brown continued at his same location, and income withholding, half his check continued to come out, Your Honor, as payment. However, that still is not enough to make the arrearages come down. I'm going to discuss with Mr. Brown some other options, but in that, income withholding has attached for and has not stopped. I would ask for a brief adjournment for another pretrial to see if Mr. Brown can come up with some other options and perhaps explore a review, Your Honor, because clearly Mr. Brown either needs new employment or a lowering of his child support, Your Honor. So just a brief adjournment is what I'd be asking. And maybe we can see if he can come up with some sort of lump sum.
All right, Ms. Brenner, anything from the people side?
Your Honor, we did have a couple of times where he failed to appear, and I gave him a break back in 2022, and then we ultimately did the bench warrant. What Ms. Underwood says is correct. He has been paying for some years. However, his arrearages have climbed over $10,000 from where we began. It looks like he had asked for a review back when we originally were in court back in 2022, but then he failed to submit any supporting information, so they just closed the review. The notes indicate that he has turned in a questionnaire for another upcoming review, so hopefully he'll cooperate this time and they can evaluate his order, because it is somewhat high. It is $938 a month, which most of the time he's paying, but sometimes he falls below, which is why the arrears have climbed over these couple of years that he's been missing, even though there have been consistent payment efforts. So I'm okay with the adjournment. I don't know. I didn't even know he was back in custody till Miss Underwood told me about this hearing. So I don't know if he posted another bond or what happened with his bench warrant. I know you said we need to address that. I'm hoping that maybe he can come up with a lump sum and he understands the importance of attending hearings at this point, because, you know, he disappeared for 3 years. I'm okay with the adjournment though, because of the payments, Your Honor. I guess long story short.
We still have this.
Okay.
Right?
All right, so I think based on
you're
a
right.
payment
Thanks.
history that I am comfortable with an adjournment, what I'll do is adjourn this to November 5th at 8:15.
And I'm going to do this, I will do the stip adjournment with Ms. Brenner's permission.
Yes, that's fine. And do we need to address the bench warrant still, Judge?
I'll just set that over. It looks like he was arraigned on that back
Thank you,
in
Your Honor.
August by Judge Ansel, and I must have been out that day. So he has been arraigned on that. So we'll just set that out to the same November date.
Okay.
So Mr. Brown, your next date is November 5th at 8:15 a.m. I've seen you've kind of dug a hole here by not appearing previously, so you know, don't do it again, because it'll only get worse. Okay. Thank you.
Your Honor,
All right.
I'm sorry, one last question. Was he given a PR bond at the bench warrant arraignment, or is there cash sitting there with the court?
It was Peter.
I'm sorry.
It was Peter.
Yeah, it was a PR bond.
Okay, thank you, Your Honor.
Okay, so you're all set for today.
Okay, thank you.
Ms. Underwood, do you need to speak to Mr. Hennegan?
I don't believe so, Your Honor.
I have a jail device, jail Zoom 1 is logged in, but the camera is off. If there's anyone there, I'm going to send a request to start the video. Okay, this is file 25-22289-FH, People versus Dewan Hennegan. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Ms. Brenner.
Good morning again, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Ron Underwood for Mr. Hennegan this morning, Your Honor.
Okay, and Ms. Underwood, where do we stand with Mr. Hennegan's case?
Mr. Hennegan continues to make good payments. So we would be asking for a 60 to 90 day adjournment to allow that payment history to grow, Your Honor.
Is that agreeable, Ms. Brenner?
Yes, Your Honor.
So we'd be looking at the end of November, or early, let's go with December 3rd at 8:15.
And I can do that stip and adjournment with Ms. Brenner's permission.
Yes, that's fine. Thank you.
Okay, is there anything else we need to address with Mr. Hennegan's case?
No, Your
I
Honor.
don't believe so, Your Honor.
Okay, then, Mr. Hennegan, again, your next date is December 3rd at 8:15 a.m. You'll log in using all the same Zoom information you used today.
All righty.
Thank you.
Thank you.
Okay, and then Ms. Underwood, you need to speak to Jonathan Scivoletto.
Yes, I do. Thank you, Your Honor.
And Mr. Grimm, do you need to speak to Ms. Crabtree?
I do not, Your Honor. I believe we're ready to proceed.
Okay, give me just a second here, Mr. Scivoletto.
Yes, sir.
All right. I'm going to put you in a breakout session with Ms. Underwood.
Thank you.
Okay, this is, here we go, file 22-20733-FH, People versus Leanne Rosanna Crabtree. We are here today for a hearing on a probation violation, and we are proceeding today by video conference. First, can I ask Mr. Grimm to place your appearance on the record?
Yes, Your Honor. Ronald A. Grimm here on behalf of Miss Crabtree.
Okay, and where do we stand with Ms. Crabtree's case then, Mr. Grimm?
Well, Your Honor, she's here having been arraigned on a probation violation. That probation violation arose out of due to a probation violation in her Jackson County case, and she subsequently has served in Jackson around 220 days, here in Lenawee for about 73. So we're ready to plead guilty to that and ask for expedited sentencing.
Okay, Ms. Crabtree, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Leanne Rosanna Crabtree?
Yes.
Ms. Crabtree, do you understand that you have a right to contest this violation of probation charge and have a trial on it?
Yes, I do.
Do you understand that throughout that trial, you'd be presumed innocent until your guilt is proven by a preponderance of evidence?
Yes.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses that you have for your defense to appear at your trial. Do you understand all of that?
Yes.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold that against you in any way. Do you understand?
Yes, sir.
On the other hand, do you understand that you have the right to testify at your trial if you wanted to testify?
Yes, sir.
How do you plead to the charge that you violated your probation by failing to report to your probation officer in Jackson County on March 25th, 2025, or any time thereafter?
Guilty.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes.
Has anything been promised to you in order to get you to plead guilty?
No.
Has anybody threatened you in any way in order to get you to plead guilty?
No, sir.
if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty?
Yes.
So you were placed on probation back in, looks like about May of 2023. Is that correct?
Yes.
And one of the conditions of your probation was that you were required to report to your probation officer at any time they directed you to report. Is that correct?
Yes.
I'm sorry, the microphone was bad there. I couldn't understand what you said.
Yes. Yes.
And did you in fact fail to report on or about March 25th, 2025?
Yes, sir.
And then it looks like you were picked up on this warrant on September
11th.
2025.
Yes.
Had you reported at any time until you got picked up?
I was only out a couple days from jail. I did an advise and a release from jail, and
I'm sorry. I gotta interrupt you because I can't understand what you're saying. I need you to slow down and speak a little more clearly.
Okay, they did an advise and release from jail, and I called my lawyer, and I was waiting to hear back from my lawyer, and I got picked up like right away. So no, I did not.
Okay. All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Crabtree has had full knowledge of rights. She had as competent counsel. Ms. Crabtree, you have a right to have an update of your pre-sentence investigation report completed before I proceed to sentencing. I would only proceed to sentencing if you're willing to waive that right. Is that what you want to do?
Yes.
Mr. Grimm, is there anything you want to say on behalf of Ms. Crabtree before the court passes sentence?
Yes, Your Honor. Ms. Crabtree is aware of the errors in judgment that she's made throughout this case. I believe that she has made considerable progress, and I know that she served over 220 days in Jackson and almost 75 here in Lenawee. I would ask that Your Honor would give her time served and then close the case at this time. Thank you.
I don't understand, Mr. Grimm. She was picked up on September 11th. How was she served 70 some days in Lenawee County?
Well, in the original charge here, Your Honor, she served 60 of the 90 days that you had ordered her to serve. Then she went to rehab. There was a little problem there. She's dealt with that through this court as well. And I believe that she has served adequate time for this probation violation, and it's close to the time.
So the initial 60 days was on her original sentence?
Yes, Your Honor.
Okay. All right, Ms. Crabtree, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, sir, I do. I would first like to apologize for any disrespect my mistakes made while in active addiction have shown the court. In keeping with my program of recovery, I often look for opportunities to admit and learn from my past mistakes and any new missteps that I am bound to make moving forward. Where I was stuck in a place of hopelessness before, I avoided any uncomfortable situations because I knew admitting responsibility would lead to change that I was not emotionally or spiritually ready to accept. I'm grateful for the time that I've served recently. That gave me a clarity of mind and desperation to live a better, fulfilling life with my partner of 16 years, who has been a great support to me in that time and deserves the best that I can give him in his declining health. I was only able to spend a short period of time back at home with him before coming here to remedy my warrants in Lenawee County. I'm happy to say that I have made regular attendance to NA meetings at the Grateful Group as my home group in town. I applied at U.S. Staffing and Fast Time and look forward to realizing my full potential in my community. I hope Your Honor accepts my apology and allows to make amends for my past mistake.
Okay, so this is a second probation violation. Ms. Crabtree had previously pled guilty to a violation also for failing to report, and so this is the second one. Under those circumstances, the court's maximum sentence on this type of probation violation would be 30 days of jail. I do recognize that Ms. Crabtree has also served some other time in Jackson County, and although she's not entitled to credit for that on this, I think that's an important factor in determining what the court's sentence is. I do think under those circumstances that time served is appropriate, so it will be the sentence of the court that Ms. Crabtree served 13 days in the Lenawee County Jail with credit for 13 days served. Ms. Crabtree, you do have the ability to request an appeal of that sentence. We will send to you 3 copies of the Notice of Right to Appellate Review and Request for Appointment of Attorney form. When you get that form, you need to sign one and return it to us. That just means you've got your copies of those forms. If you want to appeal your sentence, you need to fill out the remaining portion of that form, mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
Okay, so if you are all set for today, you can let the officer with you know that you're done with court.
Your Honor,
Yes.
are you revoking probation or is probation continued?
No, I'm sorry. Thank you for mentioning that. Probation will be continued.
I'm sorry, what was that? Sorry.
Your probation is continued, so you need to, when you're released, come over to the probation department and get in touch with your probation officer.
Okay, thank you.
Thank you, Your Honor.
Thank you, Mr. Gray.
Is he there? He's on our jail sheet. Okay. Okay. What judge now? All right. You, that's.
Yeah.
He's Judge Morgan's sentence 10 to 90 days inpatient harbor ward.
Okay. Okay, you skip it. This is file 25-22237-FH People versus Jonathan Paul Scivoletto. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Brenner.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Good morning, Your Honor. Rhonda Underwood for Mr. Scivoletto.
And Ms. Underwood, where do we stand with Mr. Scivoletto's case today?
Your Honor, Mr. Scivoletto has been making payments. However, Mr. Scivoletto was laid off, Your Honor, found a new employer who has since became ill, and so Mr. Scivoletto is no longer working there. He is working with Elmwood Staffing to try to find a job, Your Honor. He's also, I understand, going to be collecting unemployment. He just made $100 payment 3 days ago. I believe he made another one a couple weeks ago. Your Honor, what we would ask is this. We would ask for a very short adjournment for Mr. Scivoletto to be allowed to find and produce regular employment. And if not, we would ask the next court date, Mr. Scivoletto be ordered to appear in person, Your Honor.
Ms. Brenner?
I'm not really pleased with the progress on this case, Your Honor. He came in with, his employer came in and convinced you to give him a PR bond over our objections, stating he was going to be working, making all this money, he was going to be paying. That was back in May. And then he paid in June $711, in July $491, and then August $100, and September $100 so far. His order's over $1,200 a month. So we're talking less than half of what he's needing to be doing. And at this point, it looks like he's been unemployed for 60 days. So how much more time are we going to give him to find employment? That's probably not going to be adequate. So we're going to continue digging in a hole. You know, I think we need to set this for a final pretrial. He needs to either make progress or potentially plead or be remanded.
All right, I think this situation is more appropriately set for trial at this point. So how is a one-day trial sufficient?
Yes, Your Honor.
Ms. Clark, can we have a one-day jury trial date, please?
Yes, Judge. Thursday, December 18th, backed up to a jury trial.
Could we have a final pretrial as well, Your Honor?
Yeah, I would do a final pretrial on December 10th. And the court will issue a scheduling order that will get mailed out to you. So final pretrial on December 10th at 8:15 a.m., trial on December 18th at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you. Mr. Scivoletto, you can go ahead and log out then. Mr. Murphy, you're going to need to speak to Mr. Dylan Beck.
I think we can proceed on the record, Your Honor, with him.
Go to jail for Whiteman.
Research says that that's supposed to be applied appearing in Zoom, maybe?
Teresa Ward. Okay, this is file 25-22297-FH People versus Ryan James Dillenbeck. We are here today for a pretrial conference in this case. We are proceeding today partially in person and partially by Zoom. First, may I have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, may have the people.
Matthew Murphy, appearing on behalf of Mr. Dillenbeck.
And Mr. Murphy, where do we stand with Mr. Dillenbeck's case today?
Yeah, no, we have a plea agreement worked out. I can provide the court with the signed copy right here. It's for Mr. Dillenbeck will be pleading guilty to count 2 unlawful driving away of motor vehicle. The prosecution would agree that sentencing would be with concurrent probation with what he's currently doing, acknowledging that he was recently pled guilty to and sentenced to similar crimes involving pretty much the same incident, spanning multiple days, obviously. So again, I have the copy. If the bailiff wanted to come get this up by the court, he does wish to plead guilty to that. Your Honor, I was going to ask because he was just sentenced, pled guilty and was, thank you, sentenced, no, I placed it on my email, but, I think it was just in July, if I'm not mistaken, July, 18th, or maybe July 23rd. But there is a pre-sentence investigation report that was completed for those. That was, essentially was July 18th. The pre-sentence investigation report on those files was completed in mid-June, I believe. And so I was asking the court if, we want to enter the plea of guilty today, and then we'd ask the court to consider waiving, we would waive a necessity for an updated PSI. We'd ask the court to consider using that PSI again with the plea agreement being that the prosecution would agree that probation would be appropriate in this matter, concurrent with what he's already sentenced to. We'd ask the court to consider having sentencing occur today. Again, with the fact that we have a PSI that was just completed a few months ago.
I appreciate the desire to do that, but I just don't have time. This is the third or fourth one that as people have asked me to do that, and I don't build time for sentencing.
Yes, Your Honor.
Wednesday mornings. I apologize. I can't get in the habit of this and start doing it. I also think I would like to have some information, some updated information to know, what's happened since July. So,
yes, Your Honor. Thank you.
All right, Ms. McClure, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Mr. Dillenbeck, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Ryan James Dillenbeck?
Yes, sir.
Mr. Dillenbeck, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 unlawful driving away of a motor vehicle?
Yes, Your Honor.
Do you understand the maximum possible penalty for that offense up to 5 years in prison?
Yes, Your Honor.
Do you also understand that requires the Secretary of State to suspend your driver's license?
Yes, Your Honor.
Are you satisfied with Mr. Murphy and the advice that he's given?
I am, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
Mr. Murphy?
That's correct, Your Honor.
Is that also your understanding, Mr. Dillenbeck?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. Yeah. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Dillenbeck, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, Your Honor.
Do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about March 13, 2025, in the city of Adrian, County of Illinois, State of Michigan, that you did commit the offense of unlawful driving away of a motor vehicle?
Guilty, Your Honor.
has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Dillenbeck to plead guilty?
No, Your Honor.
No. No, Your Honor.
Mr. Dillenbeck, has your attorney promised you any particular sentence or estimated what your sentence would be other than as it's been discussed on the record here today?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, Your Honor.
Is it your own choice to enter the plea?
Yes, Your Honor.
Mr. Murphy, do you want to establish the factual basis?
Yes, Your Honor, thank you. Mr. Dillenbeck, were you in the city of Adrian, the county of Lenawee, in the state of Michigan on or about March 13th of 2025?
Yes, Your Honor.
And did you take possession and drive away a motor vehicle without permission to do so unlawfully, to it a 2014 Dodge Ram work truck?
Yes, Your Honor. Or yeah, sorry.
I think that satisfies the factual basis, Your Honor.
So are the people satisfied with that factual basis?
And did that, well, I want to make sure I have the correct, I just wanted to place the name of the individual on the record, so I want to make sure I have the correct information of.
So I didn't identify who.
Did this belong to, the van belong to Adrian Mechanical Services?
Yes, ma'am.
Okay, people are satisfied.
Thank you.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Mr. Murphy?
It has, Your Honor, thank you.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Dillenbeck has had full knowledge of his rights, and he has had counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to probation department for a pre-sentence investigation and set sentencing for October 31st at 8:15 a.m. Mr. Dillenbeck, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview.
Okay, thank you, Your Honor.
I need fingerprints in this file also.
Mr. Dillenbeck, can you come to Adrian and get your fingerprints done again for this file, like you had to do before?
Yeah, I'll get a hold of you and see when we can figure out how to do that.
All right, just contact my office and let us know, and we'll get them to the court as soon as possible. Is that okay, Your Honor?
Okay, thank you.
So the Adrian Police Department does fingerprints Monday through Thursday at 7:30 a.m.
Did you hear that, Mr. Dillenbeck?
Yes, Your Honor. And yes, Matt.
So just try to figure it out and contact my office when you're doing that, so that way we know we can get it to the court as soon as possible.
Okay, I'll call you after I get a hold of somebody today.
All right, thank you.
You're welcome.
Okay, so Mr. Dillenbeck, I'm going to put you in a breakout session with Ms. Teskey from the probation department. She's going to collect your contact information and give you some instructions on what you need to do next.
All right, thank you, Your Honor.
Thank you, Your Honor.
Thank you, Mr. Murphy. Could you call this attorney and see if he is, he's not, or if his client is here? All right, Ms. Underwood, you need to speak to Ms. Ward. Stepped away. Mr. Malero, do you need to speak to Mr. Whiteman?
Yeah, I probably do.
Betsy services here for Mr. Malero. She's in the hallway. You ask her to come into the courtroom. It's ready to come in. She needs to.
Yeah,
I can't. I mean, I can't have people. Okay, Ms. Teskey, were you all set then with Mr. Dylan Beck?
I am, Your Honor.
Okay. Oh,
Thank you, Judge.
Hi, this is Judge Olsey.
Ms. Underwood, you need to speak to Ms. Ward.
Just very briefly, Your Honor.
And Deontay Dill. If you have any questions, you can give our court a call, or we can zoom in and we can get this on record. Their messages if you have a cell phone.
Mr. Dill, are you there?
Yes, I'm here.
Mr. Dill, I haven't seen your attorney log in at any point this morning. Have you heard from him recently?
No, I have not.
Okay, give me 1 second. There's one device that I don't recognize, so let me just see if that is him.
Okay.
Okay, the gentleman just joined the meeting. We send you a request to unmute.
Can you hear me?
Yes. What's your name, sir?
Jonathan Betts.
Okay. Mr. Murphy, you ready to proceed?
Yes, Your Honor.
Okay, this is file 25-22377-FH People versus Jonathan William Betts. We are here today for a pretrial conference in this case. Also, we are proceeding by video conference. First, they have the attorneys place their appearance on the record, beginning with Mr. Bannett.
Alex Bannett for the people.
Matthew Murphy, appearing on behalf of Mr. Betts.
And Mr. Murphy, where do we stand with Mr. Betts' case?
Your Honor, Mr. Betts has a violation of probation in district court in front of Judge Morgan tomorrow. We're asking to adjourn this. He's intending to plead guilty to that, and then we're wanting to see what Mr. Betts' sentence ultimately will be on that, and then try to readdress this case after we know what's going on. Mr. Betts is currently in a rehab facility. My understanding is he's scheduled to be completed with that early October. It sounds like he's doing well. So again, we're just asking for one adjournment in this matter, whatever fits the court's schedule best.
Okay. About October So do you know when his sentencing date is? Did you say that?
Your Honor, he's got a violation of probation hearing tomorrow. We're gonna probably plead guilty to that. I'm not sure, usually it'd be a few weeks or so. But with Mr. Betts being currently in rehab, our intention, our hope, I'm gonna talk with the probation officer tomorrow or today downstairs, will be that he would stay in rehab or stay on probation. But yeah, I'm not sure when that sentencing date's gonna be though. So probably at least 3 weeks, I would think.
Let's go with October 22nd at 8:15.
Yes, Your Honor, my office will do a stipulation order for that date and time.
Okay. Is there anything else we need to address with the case today?
Not from the defense, Your Honor.
Okay, so Mr. Betts, your next date is October 22nd at 8:15. You'll log in with all the same Zoom information that you used today.
Okay, thank you.
Okay, you can go ahead and log out.
Yeah.
Thank you, Mr. Betts. You have a good day. Thank you, Your Honor. I'll be back for the hearing at 11:30.
Okay, thank you, Mr. So I'm gonna call Mr. Dill's case because I think we're gonna see his attorney. All right, this is file 24-21967-FH, People of State of Michigan versus Deontay Laquan Dill. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, going to have Ms. McClure. Are you covering this one?
At one point, he raised the question, what is the purpose of the United
Yes, I can.
Okay, so can you go ahead and place your appearance on the record?
Phoebe McClure on behalf of the people.
And sir, you are Deontay Laquan Dill?
Yes.
Okay, so we had this set for a pretrial this morning at 8:15 a.m. It's 10:19 a.m. Mr. Burkett is Mr. Dill's attorney. Mr. Burkett is not logged in on Zoom and has not been here in the courtroom. We tried contacting his office, but were only able to leave a voicemail message. And so at this point, I don't know that there's anything we can do other than set this for another date, and we'll send out a notice and hopefully have everyone back here next time. Is there anything else you need to address, Ms. McClure?
Nothing to add.
Okay. So I'm going to set this for a pretrial on October 15th at 8:15 a.m. So Mr. Dill, your next date is October 15th at 8:15, and we will send out a notice, and hopefully Mr. Burkett will be with us next time.
Okay, thank you. Have a
So
good
you're
day.
all set. Yep, thank you. You're all set. You can log out.
Thank you.
Okay, Mr. Malero, are you ready to proceed with Mr. Whiteman?
Yes, we're ready to proceed.
Okay. Okay, this is file 24-22035 and 25-22386-FH. People versus Allan Gene Whiteman. We are here today for a pretrial conference as well as pretrials on 2 contempts of court. In the 24 file. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Salvatore Malero on behalf of Allan Whiteman.
Right, and Mr. Malero. where do we stand with Mr. Whiteman's case today?
Your Honor, I'm going to ask to adjourn both of these files. The basis is, there's several reasons. One, Mr. Bayonetto recently emailed me a plea offer on his case, which I need to review with Mr. Whiteman. Secondly, there's a second case with Mr. Sneed that I do not have an offer for. That's, I believe, the controlled substance case. And then additionally, Mr. Whiteman has been approved to attend Dawn Farm Spera. In fact, I believe if the court permits, he will be transported today. Transportation's been arranged. And I think there is a proposed order for the court if the court allows. So that's the basis for our request. So I'm not sure which case it is. It's probably the controlled substance case. Maybe it's the Mr. Bayonetto's case. But we'd ask the court to amend all the bonds, permit him to attend this rehab. And I think if he gets a good start on that, does well, we can get these matters resolved. So that is my request and the basis for it.
All right, Mr. Bayonetto.
Your Honor, looking at the ROA, I think he's already been allowed to go to rehab. I'm not sure on the R&O case if that is part of the bond, but I would have no objection to that at this time. I just ask that if the defendant does not successfully complete that rehab, that be considered a violation and bond be revoked at that time.
Okay, then I will modify the bond so in both files so that Mr. Whiteman can be released to attend inpatient treatment at Dawn Farm Spera. He must complete the treatment there. If he does not complete the treatment or leaves the facility before completing treatment, he must return to the Lenawee County Jail. Anything else we need to address today, Mr. Malero?
No, Your Honor.
Did we get a new date, Judge?
Oh, I'm sorry.
I didn't hear it.
I did not get a new date, so let's go with October 22nd at 8:15.
Thank you, Judge. And then I'll do the stipulation in order.
Okay. Thank you then, Mr. Whiteman. You can let the officer with you know that you're done with court for today.
Okay, thank you very much.
Thank you, Judge.
Thank you. And Mr. Malero, we had Ms. Service was out in the hallway for a while, but she is no longer there. I don't know if you want to try to contact her.
Judge, I directed her to come to my office as she had some questions, and I haven't yet talked to her, but I can go get her and let you know when we're ready. That's okay with the court?
That's fine.
Thank you.
Ms. Underwood, are you ready to proceed with Ms. Ward?
Yes, Your Honor. Thank you.
Williamson. Tell the jail that Ms. Ward needs the advice of rights form. 10. Okay, this is file 25-22381-FH. People versus Teresa Lynn Ward. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. McClure.
B.B. McClure, on behalf of the people.
Rhonda, I'll do it on behalf of Ms. Ward, Your Honor.
And where do we stand with Ms. Ward's case today?
Your Honor, I believe we have a plea bargain in place. I believe there is an amended coming. We've already sent over a signed copy of the plea agreement, and I believe Ms. Clark has very generously gotten us an advice of rights, Your Honor. Ms. Ward, I believe, will be pleading to a added count, three, I believe it is, of attempted resisting, obstructing a 1-year misdemeanor, and count 2, the driving while license suspended, while the felony and any habituals will be dismissed in this matter. I believe that is the complete recitation of the plea bargain, Your Honor.
And that is correct, Your Honor.
Okay. All right, I don't have that amended information yet.
I know Mr. Sneed was having someone prepare that, and it looks like it's in the process, so it should be getting to you very shortly.
Okay. Okay, where did Ms. Ward go?
Right here, Your Honor, sorry about that.
Needed to stay in your chair, please.
I was handing the officer my paper that I signed.
Okay.
Thank you. Sorry.
All right. Okay, can you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Teresa Lynn Ward, is that correct?
Yes, that's correct.
Ms. Ward, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, driving while license suspended?
Yes, that's true.
Do you understand that the maximum possible penalty for that offense is up to 93 days in jail and or a $500 fine?
Yes, I do.
Is it also your intention to plead guilty today to count 3 on the amended information, attempted resisting and obstructing a police officer?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail?
Yes, I do.
So 1 year in jail and or a fine of $1,000. Do you understand that?
Yes, I do, Your Honor.
I like TJ whatever. I like Jalen Hurt. He's hurt. What happened? No, he's not.
I'm getting some background noise of the television and radio. I can't, whoever that is, I need to turn that off. Are you satisfied, Ms. Ward, with Ms. Underwood and the advice that she's given you?
Yes, I am, Your Honor.
Neither the prosecutor or defense attorney or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That is correct.
That is
Ms. Underwood,
correct, Your Honor.
is that also your understanding, Ms. Ward?
Yes, that's correct.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecution and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Ms. Ward, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a...
Yes, I do, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, I do, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights that I've explained to you?
No, I don't, Your Honor.
Do you understand that you're giving those rights up?
Yes, I do, Your Honor.
How do you wish to plead to the charge that on or about July 23rd, 2025, in the city of Adrian County, Lenawee, state of Michigan, that you did commit the offense of operating while your license was suspended, revoked, or denied?
Guilty, Your Honor.
And how do you wish to plead to the charge that on July 23rd, 2025, in the city of Adrian County, Lenawee, state of Michigan, that you did commit the offense of attempted resisting and obstructing a police officer?
Guilty, Your Honor.
Has anybody made any threats or promises to induce you to plead guilty to those charges?
No, Your Honor.
Do you understand that if I accept those pleas, you'll be giving up any and all claims that those pleas were given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor, I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Ward to plead guilty today?
No, Your Honor.
No, Your Honor.
Ms. Ward, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do, Your Honor.
Is it your own choice to plead guilty today?
Yes, it is, Your Honor.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Ms. Ward, let me take you back to July 23rd, 2025. Were you in the city of Adrian, County of Lenawee, state of Michigan?
Yes, I was.
And at that time, did you come in contact with Trooper Gillick of the Michigan State Police?
Yes, I did, Ms. Underwood.
And he stopped your vehicle, correct?
Correct.
And at that time, and you were driving that vehicle, correct?
Correct.
And at that time, you gave him a false name.
Correct.
2 or 3 times, correct?
Correct.
And you did that as a way to evade warrants and because you didn't have a valid license, correct?
Correct.
And you knew he was a police officer in the performance of his duty.
Correct.
And at that time, your license had been suspended, revoked, and denied. Is that correct?
Correct.
And you knew that?
Correct.
I believe the allocution is complete, Your Honor.
People are satisfied.
Okay, has the court complied with MCR 6.302 B, C, and E, Ms. McClure?
It has.
It has, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Ward has had full knowledge of her rights. She has had competent counsel. I will refer the matter to the District Court Probation Office for a pre-sentence investigation. And we will set sentencing for October 31st at 8:15 a.m.
Your Honor, may I be heard as to the issue of bond?
Go ahead.
Thank you, Your Honor. Your Honor, Ms. Ward just took this misdemeanor plea. I believe she's also on probation, Your Honor. Ms. Ward has done a considerable amount of jail already on this case. It's only a year misdemeanor. I can't imagine there's going to be a recommendation for much more. And if there is, the misconduct provision is quite a stick, Your Honor. It's my belief that Ms. Ward will make her appointments. It's my belief that she will not engage in any misconduct that would allow the court to not to set aside this plea bargain. I would ask the court, and if she does, she knows what the consequences are. I would ask this court to consider a PR bond for Ms. Ward at this time, pending sentencing.
Ms. McClure?
Your Honor, the people would object to a PR bond at this point. We believe bond is set appropriately given the fact that she did give a false identification to avoid arrest on warrants, and those warrants were namely for not being compliant with her probation. I think there's a very real possibility given this plea that she max out on this and not be given probation on these offenses. So the people would object to any bond reduction at this time.
What's the status of her probation files, Ms. Underwood? Do you know? Is she
Your Honor, she pled guilty to this violation, and she pled guilty to a violation, and she did 60 days. This was not a violent act, Your Honor. This was simply giving the wrong name.
All right. I think under those circumstances, given what Ms. Ward has pled to and the amount of time she's been incarcerated, unable to pay bond, that reducing this to a PR bond is appropriate. So that's what I'm going to do. So Ms. Ward, when you are released, you need to report next Tuesday at 8 a.m. to Mr. McCarran in the District Court Probation Office to do your pre-sentence investigation interview with him.
Okay, next Tuesday at 8 a.m.?
Correct. It's the probation office on the first floor.
Okay.
And your sentencing date was October 31st at 8:15.
Okay, thank you, Your Honor.
And Your Honor, just because she is being released and given her history, can we have a notice sent to the jail for her so that she has it in paper before she leaves the jail?
Yes.
Yeah, I think that's our normal practice, so we'll send that to the jail.
I just wanted to make sure that was on the record in case she doesn't appear.
Okay. Ms. Ward, you can let the officer with you know that you're done with court for today.
Thank you, Your Honor.
What date did I adjourn? No. Mr. Burkett logged in. He was calling that. Okay, Ms. Underwood, you need to speak to Mr. Williams.
I don't believe I do, Your Honor.
Mr. Glazier, I have not seen Mr. Russell here today.
Yes, he's here.
Oh,
I'm sorry.
So if I need people to be in the courtroom, so that I know that they're here.
Adjourn Deontay Dill to October 15th.
So, Mr. Russell, when you have a hearing, I need you to be in the courtroom. I can't send people out to the hall and figure out who's in the hall. And I know you were maybe told already, but I'm telling you now, from here forward, if you have a hearing, you need to wait in the courtroom.
Yes, sir. Okay. Stay in here probably like the first 30 minutes and then put it out in the hall.
Wait, just have a seat right there. I'll get yours to yours next.
Okay.
Your Honor, I would need to speak with Mr. Russell.
Oh, okay. All right, so if you want to step out to the iPad, Mr. Russell, I'll put you in a breakout session with Mr. Blazer. Okay, 1 second, Mr. Russell.
Yeah.
All right, this is file 25-22387-FH, People versus Patrick Williamson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Brenner for the people.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Williamson this morning, Your Honor.
And Ms. Underwood, where do we stand with Mr. Williamson's case today?
I believe we've arrived at a plea bargain in this matter, Your Honor, whereby Mr. Williamson will plead guilty to 1 count of failure to pay child support, Your Honor, a 5-year felony. The other 2 counts will be dismissed. And I believe that the intent is for Mr. Williamson to have a pre-sentence done, Your Honor, and then if the court agrees, release Mr. Williamson at sentencing to get a job and begin making payments on what is a considerable amount.
Is that accurate, Ms. Brenner?
Somewhat, Your Honor. It's a 4-year felony, not 5-year like counsel stated. So he'll plead to count 1, we'll dismiss count 2 and 3. He's agreeing to a term of probation, and then any additional jail time is at the court's discretion. But it's not likely. I think his guidelines are going to be very low, Judge.
Okay. Call the jail on this and take Mr. Williamson.
I believe we have an advice of rights, Your Honor.
I don't have that in the file. Has it been sent over?
I believe so.
Yes, Judge, I faxed that over.
I'm sorry, you faxed it over?
Yes, I did.
So has you faxed the form over to the jail?
That's correct.
Mr. Williamson, have you signed an advice of rights form?
Not that I am aware of, no. No, I haven't signed anything.
All right, we'll contact the jail and have them bring you one as soon as we can.
Okay.
Again, can you take Mr. Williamson?
Mr. Williamson, would you raise your right hand, please?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Patrick Williamson, correct?
Yes, I am.
Mr. Williamson, you've heard the statement of your attorney and the prosecuting attorney, is it your intention to plead guilty today to count 1, failing to pay child support?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes. Am I able to speak?
I just want to know if you're satisfied with her representation for purposes of entering your plea.
Yes. Yes. I am.
All right. Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Ms. Brenner?
Yes, Your Honor, that's correct.
Ms. Underwood?
That's correct.
Is that also your understanding, Mr. Williamson?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Williamson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
No, I don't.
Do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about February 1st, 2022 to February 28th, 2023 in the city of Adrian, County of Glenway, State of Michigan, that you did commit the offense of failing to pay child support?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept the plea, you'll be giving up any and all claims that that plea was given as a result of threats or promises disclosed to court on the record today, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Williamson to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Williamson, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, I do.
Is it your own choice to plead guilty today?
Yes, it is, Your Honor.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. Williamson, I take you back to February 1st, 2022 through February 28th, 2023. At that time, were you under a court order in Circuit Court, Lenawee County Circuit Court File 201504-1431 DS to pay child support?
Yes, I was.
And you did not pay all the support you were required to pay during that period of time. Is that correct?
Correct.
And you know, and I'm sorry, I believe the elocution is correct. It's complete, Your Honor.
And that order was here in the state of Michigan. Is that correct, sir?
Correct.
People are satisfied, Your Honor. Thank you.
Has the court complied with MCR 6.302 B, C, and D? Ms. Brenner,
Yes, Your Honor.
Ms. Underwood?
It has, Your Honor.
I will accept the plea that has been given understandably, voluntarily, and accurately. Mr. Williamson has had full knowledge of his rights and he has had competent counsel. The court has made no agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation, and we can set sentencing for October 31st at 8:15 a.m.
And I'm sorry, Your Honor, I forgot to mention, counsel, will he stipulate to the extradition costs as part of the sentence as well? Ms. Underwood?
Yes, we would stipulate to that.
Thank you, Your Honor. So I would just add that as well. I'm sorry, I forgot originally, but that date works for me for sentencing.
All right, Mr. Williamson, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay.
All right. All right, so we are all set for today. You can let the officer with you know that you are done with court.
Thank you.
Thank you.
I believe that concludes my docket, Your Honor.
Okay, thank you, Ms. Underwood. Mr. Glazer, you ready to proceed with Mr. Russell? Mr. Glazer, are you there? Mr. Glazer, I guess, has stepped away for a moment. Mr. Russell will proceed as soon as he's back. I'm sorry. That's all right. All right, Mr. Gargan, are you there?
Yes, sir. Can you hear me, Your Honor?
Yeah, I can. 1 second. This is file 24-21979-FH People versus Paul Anthony Gargan Jr. We are here today for a hearing on a violation of probation. We are proceeding today by video conference. Sir, you are Paul Anthony Gargan Jr.?
Yes, sir.
All right. At the last hearing, you indicated that you wanted to be represented by an attorney, but you hadn't contacted an attorney yet. So what's your status with respect to?
I could not find one that I could afford, so I'd like to be set up with a public defender, if possible.
Okay. All right, what I will do is enter an order appointing the public defender's office to represent you. And our public defender who would be handling this is already gone for today. So what I'm going to do is adjourn this to October 8th at 8:15.
Okay, Your Honor. Thank you.
I'm going to sign an order doing that. You're going to need to contact the public defender's office. I give it a couple of days for them to get a copy of the order, but contact the public defender's office and get in touch with your attorney and talk to her before the next hearing. Okay?
Yes, sir. Thank you.
So October 8th at 8:15, you're all set. You can go ahead and log out.
Thank you, sir.
All right, Mr. Glazer, are you there? Mr. Malero, are you ready to proceed with Ms. Service?
Yes, Judge, we're ready.
Okay, then this is file 25-22374-FH, People of the State of Michigan versus Betsy Lynn Service. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto?
Alex Bayoneto for the people.
Salvatore Malero on behalf of Ms. Service.
Okay, and Mr. Malero, where do we stand with Ms. Service's case today?
Your Honor, I'm asking to adjourn the matter one time, Ms. Service case. I recently received a plea offer that I'd like to review with her in depth. And so that is the basis for my request.
Mr. Bayoneto, do we need to address anything from the people's side?
No, Your Honor.
All right, so let's set this then for October 22nd at 8:15 a.m.
Thank you, Your Honor. And I will do the step in order if the court is wants me to.
I would appreciate that, please.
Anything to make the court happy, more or less. Thank you, Judge.
Okay, thank you, Mr. Malero. I think we're all set.
Thank you.
Mr. Glazer, are you there?
Judge, I did just give Mr. Glazer a call. Can you hear me?
Yep.
Okay, sorry, my video won't turn on. Oh, there it is. I gave Mr. Glazer a call and he was having issues with his computer. Something happened. He couldn't get it to work. But he said he's on his way to the courthouse. He said give him 5 or 10 minutes. Yeah. And as far as I know, Mr. Russell is going to plead, so I'm going to forward that plea agreement to the court in case it doesn't have it.
Okay. What? John is on his way over because there's a problem with his computer. So we're waiting until he gets here. Is that out for a week?
Give yourself, yeah.
No, you need to stay here.
It's just gonna be a few minutes, so.
So, no. Did you listen to that?
No, I'll have to go back and listen to it.
Oh, I mean, they didn't take the use it.
Oh,
But
okay.
the plea minutes for use, right?
I don't remember.
Sure.
There's so many today that I checked.
I'm just gonna look at that.
Right, and I'll have to like look into it. Okay. Uh,
Hey, Alex, you did plea with Coleman, right?
No, I believe that was.
No, was not you?
He that did that.
Let me look.
I like those socks.
Oh, yeah, it was. Okay, never mind.
What do you need? All right.
Can you,
Circuit court in session.
I'm having trouble on.
Maybe see.
Log in, or Frederick Shears. I just changed my password and I thought I was putting in the right password, but it's like saying it locked out. We started almost a minute ago. Fighting for me personally, not to make sure they didn't say they didn't have it. Yeah. When it gets to like going for the trip, I'm like, yeah, I think so. I'm like, I don't know. Hopefully once I'm home. No.
So we were just kind of going over. And then we have 4. They all say when we travel, we're secretly the power of the and a lot of
You have to search and dig to Russell. Yeah.
Who's the always pro Shears?
No, Ms. Glazer.
Oh.
Okay, this is file 25-22184-FH, People versus El-Shabaz Russell. We are here today for a final pretrial. In this case, we are proceeding today by video conference. First, we have the attorneys place their appearance on the record, beginning with Ms. McClure.
PB McClure on behalf of the people.
John Glazier on behalf of the defendant.
All right, and Mr. Glazier, I do see a plea agreement in the file. Are we entering a plea today?
Yes.
Okay, go ahead and state your understanding of the plea agreement, and I'll have Ms. McClure confirm.
It's my understanding that he's going to plead guilty to count 2, possession of ammunition by a felon, and with the understanding that there'd be a Killebrew agreement, that there would be no upfront jail. I would explain to Mr. Russell that if that is followed, that he would not get jail on the initial sentence, but could be subject to it if he were to violate probation.
Okay, is that a complete and accurate statement of the plea agreement, Ms. McClure?
I had placed on the plea agreement that he was pleading to count 1, possession of a firearm, not the ammunition. I don't know that it makes a difference. The penalty's the same. I guess I don't know that it necessarily makes a difference, other than I want to make sure that Mr. Russell does forfeit the firearm that was involved in this case anyway. But I did put on the plea agreement count 1. In addition, I wrote on the plea agreement that any jail sentence would be suspended. If there even was one imposed. This is an E grade, and his guidelines are low in this case, especially once the felony firearms dismissed and the habituals dismissed. His guidelines are low, so I don't anticipate that being a recommendation of any jail. But if there was a recommendation for jail, there'd be an agreement that be suspended.
Okay, so first, Mr. Glazier, is there any issue with count 1 as opposed to count 2?
No, we don't really have any issue about that, Joe.
Okay. Any issue with any of the other issues that Ms. McClure mentioned?
No, you're
not. Okay. So, Mr. Russell, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? And you are El-Shabaz Russell.
Yes, sir.
Mr. Russell, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of a weapon by a prohibited person?
Yes, sir.
Do you understand that the maximum possible penalty for that offense is up to 5 years in prison and or a $5,000 fine?
Yes, sir.
Do you understand that that requires mandatory forfeiture of the weapon?
Yes, sir.
Are you satisfied with Mr. Glazer and the advice that he's given?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court other than as it's been discussed on the record here this morning. Is that correct, Ms. McClure?
That is correct.
Mr. Glazer?
That's correct, Judge.
Is that also your understanding, Mr. Russell?
Yes,
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you right now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial. If the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Russell, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial? You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. If you have any questions about any of the rights that I've explained, do you understand that you're giving those rights up?
yes, sir.
How do you wish to plead to the charge that on or about March 2nd, 2025, in the city of Adrian, County, Illinois, state of Michigan, that you did commit the offense of possession of a firearm by a prohibited person? And has anyone made any threats or promises to you to induce you to plead guilty to that charge? Do you understand that if I accept your plea, you'll be giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea? Is the prosecutor and defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Russell to plead guilty?
No, Your Honor.
Mr. Russell, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be? If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating terms of any sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes,
Is it your own choice to plead guilty today?
yes, sir.
Mr. Glazer, do you want to establish the factual basis?
Yeah, Mr. Russell, you were in Lenawee County here on March 2nd of 2025. Is that correct?
Yes, yeah, but
I'm sorry, I'm having some trouble hearing. Mr. Russell, could you speak a little louder? I'm having some trouble hearing.
yes,
And my question was, you were here on March 2nd of 2025, not that you were in jail, but you were here in Lenawee County.
Yes.
Is that right?
yes, sir.
And at that time, you were driving in cars, or were you a driver or passenger? I can't remember.
Passenger.
Passenger in the car, and that car was driven by who?
At the time,
Yeah.
My girlfriend is here in court.
Okay, she's the owner of that car?
No, I am now.
You are, at the time, was she the owner of the car?
Nobody was the owner of the car.
Nobody was the owner of the car. Okay. And at that time, when you got pulled over, there was so found in the trunk along with some ammunition and some of your personal belongings. Is that correct?
I haven't seen any of the pictures, but yeah.
Okay. And I know that you have up to this point said you didn't know it was there, but for And at least for purposes of taking this plea, you would stipulate that you knew the gun was there. Is that correct? Yes, sir. I don't have any other questions.
Mr. Russell, had you previously been convicted of it looks like a felonious assault or assault with a dangerous weapon, which was a felony punishable by more than a year?
Prior, yes.
And had you not yet met the requirements to be eligible to possess a firearm?
You said not yet.
Not yet.
Okay, I'm sorry, I didn't hear.
Not yet.
Okay, and I guess, Judge, I would just ask that the court find, or as Mr. Glazier stipulate, that Mr. Russell did possess that firearm by constructive possession, being in the same vehicle as the firearm.
I think we already said that, Chair, but we agree.
Okay.
The one problem I had is there was forfeiture. It's not his gun to forfeit.
It doesn't matter, it still would have to be forfeited.
Well, I'm just saying, my client, as far as he's concerned, will forfeit it, but he's not the owner of that gun.
All right, has the court complied with MCR 6.302 B, C, and D, Ms. McClure? I'm sorry, I didn't hear your answer, Ms. McClure.
It has.
Mr. Glazier?
Yes, Your Honor.
Okay, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Russell has had full knowledge of his rights and he has had competent counsel. I will refer the matter to the probation department for a pre-sentence investigation interview and set sentencing for November 6th at 8:15 a.m. Mr. Russell, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background. So when you leave the courtroom, Mr. Russell, you have to step across the hall to the probation department. They'll give you a packet of information to fill out and collect your contact information and give you instructions on what to do next.
And Your Honor, just for the record, we were set for trial to begin on October 2nd, 2025. The people have already issued subpoenas for that trial date, and I will, as a result of this plea, cancel my subpoenas, but occasionally when they're non-police witnesses, they don't always get the message. So I guess just for the court's benefit, if anyone shows up on October 2nd, they can certainly be excused.
We will vacate the trial dates then.
Thank you.
Anything else for this case, Mr.
No.
Okay, Mr. Russell, you're all set.
We have to decide that. If you want to see the information, stop it off, scan the rest of the witnesses. Okay. Yeah, we'll see after that. What's that? I'll be in there probably about 2:30.
Judge, I believe that's all for me for the day. I don't know if you need me for anything else.
Yeah, no, I think we're all set, Ms. McClure. Thank you.
Okay, thank you.
Yeah, you gotta check with the probation. Okay.
Judge, are you done with me as well? Does that conclude your criminal
Yes.
docket?
Yes, we're all set. Thank you, Ms. Teskey.
Thank you.
Oh, because to show that you don't have a right to carry a gun. Yeah, back in there. go across the hall, yeah. Sentencing was number 4. November 6th at 8:15.
November 16th, my sentence.
Yes, at 8:15.
At 8:15.
Celebrating the right. I go up. I'm going. I didn't go much last year, but I'm going up tailgate tomorrow. I'm sure. Right. I don't.
I need to get to the next case because I've got one after that and we're a half hour behind, so.
Trying to get forward where I Yeah, I'll be in there too. All right, get taken care of a little bit.
Is Mr. Shears here?
I think he's up the hall, right?
This is file 24-21752-FH, People of the State of Michigan versus Frederick the Wheel Shears. We are here today for a hearing on the people's motion in limine. We are proceeding today in person. First, we have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
John Glazier on behalf of Mr. Shears.
All right, Ms. Arnold's people's motion. You can proceed with any argument you have at this time.
Judge, I just wanted to place on the record that we did not get Mr. Glazier's response until yesterday afternoon. I had called him on Friday and asked him if he could please file it no later than Monday because I had to be in Monroe yesterday all afternoon on a special prosecutor exam. So it was handed to me this morning while I was actually zooming into the court's docket. I did look at it, so I'm going to have more extensive oral argument that I normally would have based on Mr. Glazier's response. So I just asked the court to bear with me. I had a chance to read it quickly and I'll do my best.
Okay.
So we have filed a motion in limine asking to admit evidence from file 2421752FH in the trial in file 2522116FH and vice versa. In file 2421752FH, this is an incident that happened in 2023, and I'm going to put some of the facts of both incidents on the record so the court can understand the similarities between the two incidences. In the 2023 incident, a search warrant was executed at 2922 Ben Oak Highway in the city of Adrian on September 12th. Part of the basis of that search warrant was a federal confidential informant who indicated Mr. Shears had sold him large quantities of cocaine and that Shears possessed 2 kilos of cocaine at 2922 Ben Oak Highway within the last 2 weeks prior to September 12, 2023. That confidential informant indicated it was typical for Mr. Shears to keep a large amount of cocaine at Ben Oak Highway in the last year prior to September 2023. This informant also indicated that he or she knew that on September 12th, which is the date the search warrant was executed and also the charge date of this offense, that an individual by the name of Juan Solis was going to be transporting cocaine from Shears' residence to Ohio. Juan Solis was then surveilled leaving the Bend Oak Highway address at 12:47 p.m. on the 12th, and he was stopped in Ohio at 6:07 on the 12th and found with 453 grams of cocaine in his vehicle. It's our intent to attempt to present that federal confidential informant to testify at trial. We're still attempting to locate that individual. Rhino did surveillance on Mr. Shears, and he was observed at the residence at Ben Oak Highway and was particularly observed on September 11th, 2023, which is the date prior to the search warrant execution, conducting what appeared to be a short stay narcotics transaction, which I know the court is familiar. It's someone coming in quick contact with that person and then that person leaving. So on September 12, 2023, Rhino had the search warrant, and initially they stopped Mr. Shears leaving the Ben Oak Highway residence at 6:18 p.m. on September 12th. The search warrant, he was stopped and then he was detained. He wasn't allowed to go back in the residence at 6:18. The search warrant was then executed at 8:15 p.m. on the 12th. During that search warrant, there were 2 guns located, a .45 caliber pistol in the northeast bedroom closet on the top closet shelf, and a .38 caliber revolver on top of the kitchen cabinet. Ammunition was also found in the hallway closet. 8.8 grams of cocaine was located in the kitchen cabinet. A digital scale was located on top of the kitchen cabinet, and a digital scale was located in a kitchen drawer with 2 packs of baggies. Mr. Shears' personal property was located at Ben Oak, including his current U.S. passport, personal mail addressed to him, although admittedly not at that address, prescription medication, previous court documents, his current vehicle registration, and a U-Haul contract for renting a U-Haul in his name for a U-Haul location in Adrian on August 21st, 2023, just a few weeks prior to the search warrant being executed. There were also other personal belongings that appeared to be his, but those items in particular. So when law enforcement questioned Mr. Shears, they weren't questioning him about the guns. Lieutenant Street was reading Mr. Shears or presenting him with the tabulation from the search warrant. And at that time, Mr. Shears said both of the guns that were taken from the residence, the .45 caliber pistol from the northeast bedroom closet and the .38 caliber revolver on top of the kitchen cabinet were his, and that he had lawfully purchased them 5 to 6 months ago. So given Mr. Shears' personal property being within the residence, personal property that you wouldn't keep somewhere you're not intimately associated with, like your passport, your current vehicle registration, the U-Haul contract showing he has a recent association with the residence because it's dated August 21st, 2023, him being surveilled at the residence, including the day before, and him leaving the residence prior to the search warrant execution where he's detained, and him is admitting that the pistols were his, one in the bedroom closet on top of the top shelf in the closet, which is usually a place that only people who live in a residence or spend a lot of time in a residence keep their things, and the other one being on top of the kitchen cabinet when there was also 8.8 grams of cocaine located within the kitchen cabinet, and a digital scale on top of the kitchen cabinet, another digital scale in the kitchen drawer, and packs of baggies with that scale. The close location of the revolver to the narcotics and the narcotics paraphernalia ties Mr. Shears to those, because we know that drug traffickers often possess multiple firearms to protect themselves, their possessions, and their drug products. So Mr. Shears, there's strong evidence that he is associated with that residence. From Mr. Glazer's response, it looks like Mr. Shears is denying any association with that residence. So then the next case happened on August 6, 2024, and that's the 2025 file we're dealing with here. On that date, another search warrant was executed at South Winter Street, also within the same municipality, the city of Adrian, Lenawee County, Michigan. As the police go in, it's the SWAT team, SRT team, whatever they're called here, goes in first to secure the residence. As soon as they walk in, you know, they knock and announce first, that sort of thing. But Mr. Shears is walking out of a bathroom in the residence. In that bathroom, there are 22.8 grams of cocaine, that some that's on the toilet seat, some on the floor, some within the bathroom. There are also packaging materials and a digital scale of the exact same type that was found, maybe not the same brand, but the same sort of digital scale that was found in the Ben Oak Highway residence, which we will present testimony is the type most often used by drug traffickers to weigh narcotics for sale and very rarely possessed by users. There was also more cocaine and indicia of narcotics trafficking, such as numerous cell phones, packaging material, and cash found in the residence. Once again, the residence was not defendant's official registered address, but he had been surveilled there, and his car, paperwork, and other personal belongings were located at that residence in the 2025 case. So to prove the charge of possession with intent to deliver, the people must show the defendant knowingly possessed a controlled substance that he intended to deliver. And here, these other acts are both probative to show the defendant's knowledge that the substance possessed was cocaine, his motive and intent to have it for trafficking purposes, and a common scheme, plan, or system to show that he frequents the city of Adrian, uses residences that are not his registered address, but where he keeps his belonging and keeps his drugs, keeps scales and packaging materials to traffic drugs in the city of Adrian. These offenses are 11 months apart, which is much shorter in time than the cases we have cited in our brief that allow this sort of evidence to come in. The defense has cited People versus Crawford, which of course is a seminal case, saying that this case is in line with Crawford. Crawford is different than this case in that in Crawford, the two offenses were 4 years apart rather than 11 months apart. I don't know if they were in the same geographic location, but the facts and the scheme, plan, or system was not the same in those two acts. In the act that the defendant was charged with in Crawford, he was driving a vehicle that he had just purchased 5 to 10 days prior to his arrest. And when law enforcement searched that vehicle, there were drugs that were hid in the dashboard. So the fact that the car had been in possession of others prior to the defendant possessing it, and it was found in the dashboard where, you know, hidden in the dashboard where it's not obvious, someone wouldn't just see it if they purchased it. The defense theory was that the defendant, someone else had left drugs in the car, and the defendant, or maybe was even attempting to frame the defendant, and the defendant didn't know about the narcotics that were in the dashboard. The prosecution sought to use an act 4 years earlier where the defendant was caught actually selling drugs. And in that case, the court said that the factual relationship between what happened in 1988 and what happened in 1992 was too remote for the jury to draw any inference other than the prosecution was trying to say, this guy's bad, he's a drug dealer, so he must have known this stuff was in this car that he had just purchased days prior. Here, the facts of the incident are much more similar in nature, same drug. The defendant is using a residence not his in the city of Adrian. They're only 11 months apart. Similar paraphernalia for drug trafficking is found in both incidents. So we would assert the cases that we cite are more on point to this incident. It should be allowed under MRE 404B, and the danger, the probative value is not outweighed by any unfair prejudice, because any prejudice to the defense is only because it's probative. None of it is unfair. So we would assert that both 404B evidence sought to be admitted in both files should be admitted. Thank you.
Right. Okay, can I have a second? Okay. Your Honor, the prosecutor complains that I just served her with this yesterday. I just prepared it yesterday. I have a schedule too, and I got other things to do, but I have been working on this, and I prepared and I filed it yesterday. If she wants to take time to respond to it, fine. She's indicated numerous facts here that are not sworn to, are not in evidence, they're not even in her motion. If she wants to send me an update on what she's claiming these facts are, we'll respond to each of those. But certainly, we don't believe that this meets the level or admissibility under 404B. I would note that it's my understanding probably one of the chief causes of cases being reversed and sent back are improper use of 404B evidence. It's highly prejudicial in this case. I've cited the rule on that I think it's 403 in the chat. And even if the court found this somewhat probative under 404B, the prejudice and the confusion that it would cause under 403 would certainly outweigh its being admitted. In this case, they have one case here against my client where some of his personal belongings, when I say personal belongings, they're talking about a passport, some mail, a U-Haul contract. None of those are at the address where those are found. They are found at a friend that he knows, Juan Solis in Sprague, Wellington Savage. And there's a logical explanation for them having that paperwork. As to these guns, Your Honor, the guns, interesting, and we're going to file a motion on this as well. The guns where this officer testifies that my client said they were his guns, miraculously is not recorded. He's in custody for 6 hours. All the recording devices are there, but the officer says, well, yeah, he made this. My client vehemently denies that. So we don't, that's a question of fact for a jury, but it isn't established for 404B purposes. We don't have any testimony or any sworn testimony at this point. As to the second charge, Your Honor, we again are going to file some motions on that. But it's interesting to note that this is just some drugs that are found in the bathroom. And there was a co-defendant on that case. You took a plea from her yesterday, and part of her plea was maintaining a drug house. She was forced into an agreement saying that she did not know about the drugs in the bathroom. We think that's that's a forced plea bargain on her, but we would certainly believe that we can argue that, yeah, those were her drugs. She knew there were drugs there, and she maintained a drug house. So with these additional, once we get facts that the prosecutor argued, they will respond to them. But we don't think there's any way that this should be allowed under 404B. His paperwork being at a house is such a weak case that I don't think the prosecutors have a chance of. We'll probably file a motion for a directed verdict on that one, or a motion to quash on that as well. We've got until the 22nd to file motions. We plan on filing that as well. And they need to bring in the facts of this second case where he walks out of the bathroom to have any chance of winning the first case. It is so weak. Like I said, there's some paperwork there, and that's it. It's not his residence. He's not found with any cocaine, and we'll deal with that one as it comes to trial.
Okay, so which of the facts that I've heard about these circumstances are in the record and which are not in the record?
Nothing that she said today is in the record.
Judge, I'm not sure what you mean by the record. Mr. Glazer.
Is there evidence? I mean, you're making an offer. Are you just making an offer of proof that at trial, these things about his personal effects being in the house and all those things are I mean, I'm not inclined to rule on a motion to eliminate on just an offer of proof of what the testimony will be.
Right, I guess.
Because I can't, because the testimony might change and then the ruling's no good.
Right, I mean, I guess it is an offer of proof based on, that comes from the police reports that Mr. Glazer's had since he's been involved in the case. I mean, we can have a factual hearing. I'm used to the court making a ruling based on an offer of proof. I guess if the evidence at trial would be different, the court could make a different ruling,
Well,
but.
the facts here seem to be significantly in dispute. And so if you'd like to have an evidentiary hearing on the issue, I'm happy to do that and then make a decision. But if all I have to make a decision on is you're telling me that this is what the evidence at the trial will be, I'm not gonna rule. I'll just wait and rule at the trial when I know what the evidence is.
Right, I think it's important we resolve the issue so we know who we're gonna subpoena for trial, and also we may be seeking to consolidate the cases for trial. Haven't made that decision yet, so I guess we can have that might be appropriate to have an evidentiary hearing and then see where the court ends up.
Okay, and that's fine.
And I understand that Mr. Shears is gonna contest, what law enforcement is gonna testify to, but I don't expect them to testify to anything different than what I've represented on the record. I mean, it's just gonna be a factual dispute between the parties. Plea.
Oh, okay, and then again, I would have to then make some further findings about those factual disputes before I could rule on the admissibility of the evidence.
Yeah, I don't know if
he says I found X, or Mr. Shears said that the gun was his, and Mr. Shears says, no, I never said that, and there's no recording, then I need to make a credibility determination.
Correct.
Before I can resolve that issue and then use that in a manner to help me determine the admissibility issue.
Yeah, that makes sense. And I guess Mr. Glazer will have to make a decision about whether he wants to subject Mr. Shears to cross-examination at a motion here or not.
Yeah, I mean, that's
right. Okay.
Bridges will have to cross, but again, I don't think it's appropriate for me to rule on the motion where it's the underlying facts that would support admissibility of the 404B evidence are disputed. So if you'd like to schedule that.
Why don't we schedule it now while we're here, if we can do that?
I have another motion I have to hear that was supposed to start at 11:30, so if you want to come around back and talk to Francis, you can do that, but I can't do it on the record right now.
Okay. Do you want us to go back this way, Josh?
Back that way?
Yeah. Take, yeah, I guess so. I think that one's needed.
I got it.
This is file 25-22175-FH, People versus Nicholas Montgomery Blevens. We're here today for a hearing on the defense motion to quash the information and dismiss. First, we are proceeding partially today in person and partially by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Fenton.
Alex Fenton for People.
Thank you, Your Honor. Matthew Murphy, appearing behalf of Mr. Blevens.
All right, Mr. Fenton, this is your motion. You can proceed with your argument.
Yes, Your Honor. Thank you. Now, I wanted to start with, I understand this issue may sound kind of pedantic to get into it, but I want to first address what I mentioned in my brief, which is that what I could tell from the district court hearing, from the preliminary examination hearing, it seemed as though the district court said that it was acceptable for Officer Cassaberry to seize Mr. Blevens with the intent of investigating the crossing of the street, the violation of that civil infraction. And as I'd argued, that has not been clarified in Michigan courts, that you can use under Terry, seize a person to investigate a civil infraction. Obviously, Terry involved an on the street pat down search for weapons of a person, and they believe that he was engaging in criminal behavior. Now, I'm bringing this up because I believe that would entail a different level of suspicion. What I'm arguing this about is that if Officer Cassaberry believed he wanted to investigate something, I believe that was inappropriate under Terry. If Officer Cassaberry believed he had observed probable cause to seize a person, to arrest a person, to cite them, that's where I'm saying there's a difference there, Your Honor. And again, I understand is kind of hyper-technical, but I believe it was important because the suspicion level is different. Reasonable suspicion to detain a person under Terry is different than probable cause to arrest a person and issue a citation. Again, the Fourth Amendment says that you have to have probable cause. So I'm arguing this to say that Officer Cassaberry must have had probable cause to believe that the person that he observed violated a civil infraction, not merely reasonable suspicion. Now, if that makes any difference or not, I believe it does, again, because of the fact that suspicion is enumerated as differently. Now, I'll move on to the infraction itself. As I've argued, the stop or the seizing of the person was in for an alleged violation of the statute, pedestrians in the highway, and I've argued in my brief. When you look at that, it does say it's not ambiguous. It's clear. It says that a person who travels in the main traveled portion of the highway. And again, I've argued in the brief. I believe that in this situation, Officer Cassaberry misinterpreted the statute, and that goes back to, again, if he had reasonable suspicion or probable cause. I argue that he could not have had simply reasonable suspicion. It must have been probable cause. And again, I'm arguing that he had insufficient probable cause because he observed him, as he testified, walking in the road, but on the side, not in his direct path. He didn't have to move out of the way. And as I said in the brief, the question then becomes, when you look at the cases, or the one case or two that talk about the statute, you have to look at it in its totality. I don't think I cited a case in my brief, but it's been pretty clear in Michigan jurisprudence and that pedestrians have as many rights in the roads as motorists, that they have to take precautions, they have to act appropriately, but fundamentally, pedestrians have every right to use the road as a motorist does. And that's why this statute, when you look at it and how, if a person violates or not, you have to look at the totality of the situation. This was a person walking down the street, as I had said. This was a residentially zoned area in Adrian. The city had, or the street had no markings on it. It had no side markings. the person was walking not directly in the path of the traffic at the time, which was Officer Castleberry and his partner. And as the cases have said, you have to look at the totality of it. And I'd argue that it was inappropriate, it was incorrect that he was violating that statute when Officer Castleberry initiated his traffic lights and tried to seize the person. Now, I'll acknowledge that my argument is based upon watching the video that shows once Officer Castleberry gets out of the vehicle and the camera shows the individual, that person seems to be well onto private property. Whether or not he was, I mean, I guess we can accept the argument that the person may have been on public property when the overlight heads came on or the overlights came on. I believe ultimately for our argument that doesn't really ultimately matter. I don't think I really pursue the idea that he couldn't stop him under Cherry on the public or the private land. Again, if the prosecution wants to argue, and I think that even if it was on the sidewalk, it was, again, he was trying to stop him for a civil infraction that was incorrect. Now, the identification of the person being Mr. Blevens was made through testimony. Officer Castleberry said it was through the voice. It was clear that the person, Officer Castleberry acknowledged that the person had a ski mask on. When they were walking, they couldn't visually identify the person. It was through the voice. And again, that was after they tried to stop for the civil infraction. So, Your Honor, again, I would argue that it was inappropriate to seize the person for that civil infraction, that they never committed the crime or the civil infraction of walking in the roadway inappropriately. Again, you look at the time 10:30, I believe, or maybe almost 11:30 or 11 o'clock at night. There was no other cars. He was not traveling in the main traveled portion of the highway. So I'd ask the court to rule that it was an illegal stop. That again, that seizure was illegal. I did argue about the knowledge that Officer Castleberry may have had in regards to the warrant. I would ask the court also to, I guess I have a hard time understanding the statute says that a police officer may, seize a person if they have positive information. I'm trying to understand what that definition of positive information is. I wasn't able to cite definitive cases, but I believe it's more than a belief from viewing a list from before. It's not the same. Officer Castleberry, the situation didn't involve Officer Castleberry communicating back to dispatch saying, I have, Nicholas Blevens here. Is there an active warrant for him? Dispatch, we relating to Officer Castleberry, yes, we do. It was, again, the Officer Castleberry, it was his belief that there may be a warrant based upon a list that he had viewed. And as we all know, warrants can be taken care of within 24 hours. I mean, if this was a warrant for failure to appear and pay on a civil infraction, that warrant could have been taken care of within a few hours of Mr. Blevens appearing in court. So again, I would argue with that was not, didn't rise to the level of positive information that there was an active warrant. So again, I would ask the court to say that it was an illegal stop for the stopping the person for the civil infraction, and that at the time when they did identify him as Mr. Blevens, that they needed more information to actually legally arrest him for the warrant. Thank you, Your Honor.
Your Honor, I guess just before I get started, just for the record, I did have Officer Castleberry subpoenaed for today, just in case we would have time to maybe take some testimony and make this an evidentiary hearing. I did reach out to your staff. Ms. Clark did indicate that the court's docket was pretty slammed this morning. She didn't think we'd be able to get into that. Officer Castleberry was at training today, so I told him just stay there. And so if the court does want to hold an evidentiary hearing, we can certainly do that. And Officer Castleberry can come in and testify. However, Your Honor, I don't believe that is necessary in this case. I am not quite sure I completely understand Mr. Murphy's assertion that it needs to be a different level of suspicion for an officer to come into contact with a suspect in any criminal case. Your Honor, I think it's well settled law at this point that an officer needs reasonable suspicion that crime is afoot in order to interact with somebody, seize that person for the purposes of terror. For example, throughout the law, as in OWI cases, if an officer it observes someone make a right-hand turn without using their turn signal. Failing to use a turn signal is a civil infraction, but that gives an officer the requisite reasonable suspicion to stop that vehicle and investigate a crime. What unfolds afterwards is really irrelevant when determining whether or not that initial contact was lawful. This case revolves around Mr. Blevens was walking in the street. Officer Castleberry testified to that repeatedly at the preliminary exam. Officer Castleberry was driving down the street. He witnessed somebody walking in the main traveled portion of the road. It is a side street. There are no markings oftentimes on side streets because traffic has to move in and out with whether or not vehicles are parked there. If there's another car coming at you, you have to move out of the way. The entire roadway in that situation would be the main traveled roadway. Regardless of whether or not this happened at 11:30 at night, that doesn't change the definitions under the statute. Officer Castleberry saw someone walking in the main travel portion of the roadway. He testified that there were sidewalks that were available, that were not obstructed. So in a situation like that, he has the requisite reasonable suspicion to interact with this person. Mr. Murphy did submit the body camera footage as part of his exhibits. If you watch that video, you see Officer Kessler gets out of the car and immediately tells the person, "Stop, you have to come talk to me," because he's initiating this investigation. That person does end up being Nicholas Blevens. Officer Castleberry, despite his command to come to him, Mr. Blevens repeatedly refused those commands. At that point, Officer Castleberry begins to realize who he's dealing with because he's arrested Mr. Blevens several times. He knows who he is. And in any event, Your Honor, a lot of these facts are more appropriate for the jury to decide. This is a case of resisting arrest. Being a lawful stop is an element of the crime. We have to show, for bind over to be proper, that there's probable cause to believe a crime was committed and that the defendant committed it. Officer Castleberry established that Mr. Blevens had been arrested by him several times. He knew who he was. And again, Your Honor, he had the reasonable suspicion to stop Mr. Blevens because he saw him walking in the street. Again, Your Honor, should the court require more information from Officer Castleberry, we can certainly have an evidentiary hearing to elicit some of that. But again, I would submit to the court that that is not it's not needed in this case because Officer Castleberry did identify everything that he would need to engage in a proper stop of that suspect. So I'd ask that the motion be denied at this time.
So I'm clear, Mr. Bano, it was a reasonable suspicion that the person had violated the law by walking in the main travel portion of the highway. Is that?
Yes, Your Honor, that was the basis of the stop originally.
Okay. Mr. Murphy, do you care for any rebuttal?
Yes, Your Honor, thank you. I do want to reiterate that Terry versus Ohio, again, it said that they can do a pat down on the street search of a person when there's there's suspicion of criminal activity afoot. A civil infraction is different than criminal activity. And as I cited in my brief, it hasn't been flushed out with cases, but it's been acknowledged recently that yes, the notion of using Terry to justify seizing a person for a civil infraction has not been clarified. Now, the people did cite in their brief People versus Chapo, and People versus Chapo, that's a good example of the fact that the motor vehicle code, section 257742 is the statute that says that an officer can seize a person if they believe the person's committed a civil infraction that's a violation of this code, meaning the motor vehicle code. But again, it goes on to say that they have to cite the person, and they're citing the person for that. Now, I understand it gets pretty muddled here, but what I'm trying to say is that reasonable suspicion is not sufficient to seize the person. He must have had probable cause to do it. He must have had probable cause, and the statute itself also says that it goes into that very section, talks about giving them the citation. Now, why that's again important, because the Fourth Amendment says that you cannot seize a person absent a warrant unless it's probable cause. So the Michigan legislature can't create a statute that allows an officer to seize a person with less suspicion, except for motor vehicle code. I mean, as we all remember, when we talk about Fourth Amendment jurisprudence, there is an issue with motor vehicles and their inherent, it's I want to call it flightability. The fact that when you're dealing with a person in a motor vehicle, the Fourth Amendment allows for more restrictive behavior. Again, seizing a person, that's why it's in the motor vehicle code, because if the officer sees a person committing any of these speeding ticket or any civil infractions, the motor vehicle code said, yes, you can seize them. And it talks about seize them for the purpose of doing a vehicle check, getting a vehicle record. It does not say that an officer can stop a person, a pedestrian, just any person, with reasonable suspicion because they believe they're violating a civil infraction. It says that they could stop a person for the point of issuing a citation. Now, it doesn't say that they can stop a person if they have reasonable suspicion of that citation. It says for the purpose of issuing that citation, which I'm arguing again, would require them to have a probable cause standard. The people's
I'm confused. So a police officer sees someone jaywalking.
Yes.
And you're saying that, well, police officers seeing that person jaywalk, they must have something more than reasonable suspicion to go over and say, you need to stop so I can write you your ticket?
The question becomes, when the officer sees the person jaywalk, okay, so they observe the person walking across the street. The officer must have probable cause that that action is violating some civil infraction, not just, I believe it might be. I believe that I need to investigate this to see if something else. I need to investigate it further. It's that the suspicion level has raised to probable cause suspicion. Now, take, for example, the jaywalking.
So when can an officer, if ever, operate under Terry?
Well, under Terry,
that scenario. So
again, this is why I knew I was going to have a problem with this, because Terry says that if the officer believes that he's engaging in criminal activity, then he can have reasonable suspicion of criminal activity, then you can seize the person. And then there's limitations on that. You can't do a blanket investigation of everything. You can, Terry says that you can do a pat down search for weapons on the person. It doesn't say you can turn their pockets inside out or anything like that. It says you can do a pat down search for weapons on the person on the street if you have reasonable suspicion they're engaging in criminal activity. Now, a civil infraction. So the person, again, let's take Mr. Blevens. He's walking in the street. So the officer observes the person walking in the street. As I said in my brief, there's far more entailed in whether the person's committing a civil infraction than simply the action of walking in the street. I understand Mr. Bayanetto said we should ignore the time, but that, according to the cases and even the statute itself, I mean, all of that comes into play, whether or not it was the main travel portion of the highway. So that's where I'm starting to say here, the officer, he may believe, okay, I think this person might be walking in the street in violation of the civil infraction. And I understand that I have no way, this is ultimately kind of wasting the court's time, because I can't, I mean, I would assume that Officer Casper would say I had reasonable suspicion, I had probable cause. But what happened at the exam, what the district court said was to investigate. And again, that's why I fleshed that out. There is a difference between reasonable suspicion and probable cause. Obviously that they exist, that the fact that they exist means there's a difference. An officer observed a person. Again, let's just go to Terry. He's walking on the street. He thinks he's trying to case out a bank. That's criminal activity. Now he says, well, he wasn't engaging in criminal activity. He was walking on. Let's say he thought that there was a civil infraction that says you can't walk on the sidewalk during a certain time, but his belief that civil infraction was incorrect. That's why I'm starting to say, well, he didn't have probable cause of an actual infraction. He had suspicion that something might be going on. But that suspicion is not of criminal behavior, it's of a civil infraction. So if he observes and he's definitive about it, yes, I have probable cause and I observed him do these things, then I'm saying yes, obviously he can seize the person and engage or issue the civil infraction. But if his intent is just to investigate because I have a belief, I feel like I'm talking in circles around, I apologize. Does that make any differentiation to Your Honor? Is that helpful, or does Your Honor want me to brief this issue further?
No, I think I have an understanding of it. What I haven't had an adequate opportunity to do is review the transcript of the preliminary examination, which I think for purposes of a motion to quash, I'm limited to the record at the preliminary examination. So I don't think I'm allowed to develop that further with an evidentiary hearing. What I will do is take this under advisement and go through the transcript more closely and issue a written opinion order once I've had a chance to do that.
Thank you, Your Honor.
Thank you for your time.
Thank you for your time, Your Honor. Mr. Blevens, I'll be in touch with you, okay?
All right.
Neither of them showed up. They had a hearing the other day, and I'm sure that